Hey there. Do you ever wonder how the rich seemingly get richer year after year while you're still struggling? Or do you wonder, what are you going to leave behind for your kids? What kind of legacy will you leave for your heirs? What about you'd like to know more about financial freedom through passive and residual income? If any of these are topics you'd like to know more about, but you don't know where to start, let's get connected. I have a 10-part strategy to grow, protect, and transfer wealth that I call Pitranomics. I'm Juli Pitra. Join me in my Facebook group, and let's grow together. See you soon. Hi, everybody. It's Thursday again, so it's time for Pitranomics Thursday Talks. Pitranomics is my 10-part strategy to grow, protect, and transfer wealth. And I'm really excited to discuss some of the strategies with you. Today, we're going to talk about getting professional help. That's one of the strategies. And we have a special guest speaker, and her name is Sarah Dill. She's an attorney with the Dill Law Firm. Wonderful woman. Now, let me just spout a little bit. She does real estate law. She does estate planning. She does contracts. There's probably some more things I'm missing out on. There might be more worthwhile to try and talk about what you don't do than what you do. Okay, so whatever. Anyway, I'm really excited to have you talk about some things. So if anybody has any questions, her information is going to come up in the presentation. I'm really excited to hear some gems with Sarah. Sarah, thank you so much for joining me tonight.
Thank you so much for having me.
So tell us a little bit about how you got into the law, and then we'll move on through things.
Sure. I opted quite a bit of time ago to either be a doctor or a lawyer, and several people said, man, you argue so much, you should just go to law school. So I
was born.
Yeah, pretty much. No, I actually was a teacher with Dallas ISD and saw a lot of things that could be improved upon and areas in which I could help. And I felt that the best option would be to attend law school as opposed to going to medical school. I just felt that it was a better path for me, and law school just made so much sense once I actually got there.
Okay, no, I understand. That's awesome. Thank you. So one of the things that first let's talk about is what Pitranomics is. And it's the 10 parts of the strategy to grow, protect, and transfer wealth. Here they are. The one we're going to talk about today, like I said, is the get professional help. There is nothing wrong with saying, I don't know how to do everything that it is that I need to do in order to get my goals accomplished. So find your professionals. Now, that's sometimes easier said than done. You want to find someone that's competent. You want to find someone with whom you have rapport. And by competent, I mean in the area you need for them to be. So, for example, maybe you won't get the best tax attorney to handle your real estate litigation. Doesn't mean they can't do it, but maybe you need to look for a litigator in the real estate community. Specialization is important. So you have to understand what your needs are, and you have to learn how to communicate what your needs are to the professionals that you're looking to hire. So don't shy away from the first part, which is what is it you want to accomplish? Know your goals, know where you're trying to get to. And then when you work through the strategies, getting the specialists, the professionals to help you is an integral part of making sure you get your goals accomplished. Now, because this is StreamYard, let's just do a little housekeeping here. We've been struggling a little bit with the platform because what I want is something to be really interactive. So right now, everyone that's in StreamYard, I'm going to go ahead and bring on stage so that people can ask questions. But please be mindful if you're not speaking to keep your mute on. We're going to try something else. We're going to go back to Zoom next week and try streaming from that. And we're going to be playing with this platform for a while. So I will and if you're on stage and I would really appreciate seeing your face, because it's hard to just look at the blank. So I'll probably just push back to to the backstage if you're not showing on camera. That way I can see. And I'm going to put my glasses on so I can see. So back to, oh, Shamir, can you help with the layout so I can have everybody see the presentation? And let's go to the next page. Oh, I like that. I appreciate the help there. Okay, so the next one. Can we get Sarah on stage? Oh, wait, there she is. First of all, there's that beautiful picture. And like I said, we're going to be playing with this, so be patient. Sarah not only has a degree in law, she has an MBA as well. So she's had some business training, some business experience. She is the managing partner at the Dill Law Firm. And that's no coincidence that her name is Sarah Dill, and it's the Dill Law Firm. If you want to take a moment and get her contact information, we will put it in the chat and we will put it in the comments. But if you want to take a screenshot of that, have at it. I'll give you 5, 4, 3, 2, 1. Hopefully you caught it. Let's move on to the next one, the next screen. So real estate law. Let's talk about that. That's how I met Sarah, through a real estate issue. So it's probably more than this, but it's real estate is, I guess in real estate, you deal with mostly transactional faux pas. I'm going to let you talk about that. But in real estate, there's buying and selling, there's partnerships and joint ventures, and there's areas of dispute. The reason why I could come up with this is because I had an area of dispute in a partnership joint venture regarding buying and selling of real estate, which is how Sarah knows me. I will say that mounting some kind of lawsuit is not for the faint of heart. And going back, I think what I wanted, which was justice, maybe wasn't what I should have looked for in a lawsuit. But I learned so much through that process that I think it was still a valuable experience, even though I did not win or prevail in the suit. And anyone that wants to ask me about that, we can come back to that. But Sarah, if I can let you just chat a little bit, what is the essence of your real estate practice?
Well, I actually handle both litigation and transactional work, which is not common amongst all attorneys. Typically, in real estate, I've found that there's attorneys that tend to shy towards one or the other, whether it's litigation or transactional work. But I clerked for an attorney in DFW that actually really enjoyed both, and it taught me a love of both of those areas as well. So the real estate matters that we work on are not just the everyday doldrum of contracts. I tend to handle the disputes and they can be contractual disputes, they can be disputes over land themselves, or just disputes that have to go straight to court, depending on what was going on. But usually there's a contract issue that is the basis of dispute when it comes to real estate. And that tends to be a lot of the cases that I see. But there are problems that you could have with joint ventures. I have plenty of clients who've entered into joint ventures verbally and invest money in real estate by building, some of these constructed residences, for example, and the entire time the lot that they're building on is in one of the friends' names in the membership. So if there's no agreement in writing and you don't let a title company know that you're putting money into this property and expect a payout, you potentially run the risk of not actually receiving anything once the property is sold. There's, simple things like that my job essentially revolves around making sure that my clients can either avoid getting into a mess, but much more often it's cleaning up the pieces after they've kind of imploded an idea that they had, and now we have to fix it on the back end. It's really important, in my opinion, for people to reach out to an expert, to an attorney, to a CPA, somebody that's a professional in their field before getting involved in some sort of transaction. Because quite frankly, when you don't know what you don't know, you can create more problems for yourself.
Exactly. And we had some kind of contract, my former business partners and I, but the issue with the contract that we signed is there was no remedy in the event of a breach. If one of the partners did not do what they said they were supposed to do, the only recourse was to litigate. And by that time, what you just spoke about, in my case, I was not on title. and I had no control. I put a lot of trust and a lot of money into people that did not have my best interest. So I'm a little sour on partnerships, not completely because I'm still in them, but I feel like there needs to be a lot of communication. Even beyond the contract, you need to know how to talk to your partner. And if you can't talk to them about the hard things, you don't even need to worry about trying to develop a contract with them. Just don't do it. Do something else. That's Juli speaking. Because what Sarah does, and the attorney that I met, the one that introduced me to Sarah, was trying to clean up a mess that took years to get into, and the communication was not there. The trust was no longer there. The respect was no longer there. There's just nothing good to come from such a thing. So, how do you prepare people to go into partnerships and joint ventures with the best possibility of success?
I think it's really important to talk to the partners at the table at the same time. So if I'm representing the new entity, for example, then there has to be documentation that's filed. For example, people that are going into partnerships in my office, they're going to sign a hold harmless, and they are also going to sign a document that says that I cannot represent either party in regards to the entity or any contracts that are made after they decide they don't want to speak to each other, or if they have some issue down the road. So that way, it forces transparency. Whatever partner A tells me about the business, partner B is going to hear, because I represent the entity at that point in time. So I think that's the best way to do business. And I handle, similar title closings that way. If you have, for example, creative financing, seller financing deals, everybody is at the table so that there's nothing that's hidden. I think sometimes attorneys get a real bad rap for how we handle business. And quite frankly, if you put all the cards on the table in those situations with partnerships, there's more information that you can see, everything that's easily digestible and talked about, so that you leave no rock unturned. All of the hard questions are asked and answered in the operating agreement draft before it's finalized, so that the partnership can thrive. Because if you are trying to hide something from your partner, then you probably shouldn't be in a partnership to begin with. If you ask those questions ahead of time, I think it's easier along the way.
Right. One thing I will say about my partnership with my former business partners, it was mostly flipping houses. Now, at that time, I had never used any hard money. I am actually learning a lot using hard money, because they require you to provide them with a great deal of information about your expectations. That's a partnership. There are contracts there. They tell you how much money you're going to get, when you're going to get it. You have to let them know what you plan to spend it for, how soon you're going to be done. There's a lot of expectations being presented on both sides that we did not do, my former business partners and I. They were like, we need money. I gave them money. I didn't get it back. So that's kind of how that went. Lenders, hard money lenders, on the other hand, there may be a time or two they don't get the money back, but they're doing an extreme amount of due diligence on you and on the project to minimize that risk of them not getting the money back. So at the very least, do the due diligence on your partners and on the partnership that that hard money lender is doing. Do you agree with that, Sarah?
I agree. I think that the more information you can find about your partnership and about the goals that you have, the less likely you're going to have to worry about a wind up later, or about, a termination, if you will.
Okay. And then in business, there are different organizations, formations that are made. What are some typical, let's say, real estate related or business related formations or organizations that you work with?
I tend to see a lot of limited liability companies, so LLCs. I think
Mhm.
that's the big go to for a lot of individuals that are looking to protect their assets. If you're going to purchase something and you want to, you're married, you have family, if you're running a company, you want to make sure that something happens, you're in a car accident, the 5 flip houses that you were purchasing, or that you purchased and are now using as rental income, won't necessarily be a part of the assets that somebody filing a lawsuit against you can actually get to. So the LLC is a really good way to go about that. There's also limited liability partnerships. Most individuals are not getting into that. LLPs, if you want to partner with somebody in an LLP, you kind of need to look at like the liability of the partners in the actual entity. You can have a general partner and a limited partner in those situations. And then there's also corporations. Those are very different. I don't necessarily recommend that people sign up for a corporation unless you've actually spoken to a tax specialist. These particular entities have different methods of taxation, and the LLC tends to provide the best option, which is essentially pass-through taxes. So you'd only get taxed once. There's different ways to go about also considering tax shelters in each of these situations, each of these entities that you create. So your goals need to be discussed with another professional, whether that's your attorney and an accountant or your CPA, or if you happen to be one, right, to go ahead and discuss what your long-term goals are and how you would like for that to work.
Okay. And as you can see, I was writing on the presentation here, and all of a sudden it has stopped letting me write on the presentation. So one of the fun things about dealing with platforms is they don't always work as expected. What are some common compliance issues? Because I know a number of people that have LLCs or corporations, and they do nothing to keep that corporate shield intact. Can you speak to that a little bit?
Absolutely. One of the big factors that people tend to not adhere to, in my experience, is transferring money. So if you have an LLC and you're the only person that is the member of the LLC, you're also your only employee, for example, and you have funds coming into your business, it is very important that if you're going to pay yourself from your business, that you actually have a check or you're paying yourself validly, rather than transferring from your business bank account to your personal bank account without essentially accounting for the checks and balances there of why you were getting paid at that point in time. There's concerns there and ways that you open yourself up to liability. It allows one to what's called pierce the corporate veil, which means that if you have an LLC to protect your assets, but you are playing a little loosey-goosey with how you move your funds from business to personal, then somebody that sues you for, say, getting into a car accident and it's potentially your fault, they can now get at your personal assets because you're commingling those funds. And it opens you up to a whole world of possibilities and negative impact for doing so.
Okay, because I can't write on the presentation itself, I'm going to say be careful about commingling funds.
Absolutely.
Commingling have a hyphen, anyone knows? Or no hyphen?
No hyphen.
Okay. What's another common compliance issue that people tend to ignore?
One that I would say is creating LLCs or really any entity and then not actually having the proper paperwork. I have spoken to several people, both clients and also individuals that have just kind of reached out for some information, but that they are going to say Rocket Lawyer, what is it, Rocket Zoom, like Legal Zoom, things like that. They don't necessarily follow all of the state compliance issues and then federal issues as well. So if you don't have somebody reviewing your documentation, you can potentially end up in problems. That's not to say that those documents aren't really great places to start, and they certainly help individuals that are not available, maybe don't have as much capital to get things going, to pay for, a full, very large law firm starter packet for business needs. So it's a good way to go. But if you don't have those documents, you can potentially get into issues, especially when selling real estate. You may not want to purchase or get yourself registered with the Secretary of State under an LLC, for example, and you just effectively pay for the name, but have not filed the correct operating agreement, or rather built the correct operating agreement. So you may only have a certificate of formation which you have to file with the state, but then fail to put together an actual operating agreement and any accompanying resolutions that you may need for title companies in order to actually sell property that you purchase. So there's little nuances along the way that you need with this paperwork. And unfortunately, there are a lot of companies out there that are making documentation and then not telling the customer how to use that documentation or what it's important for. I have a client that just came in with a binder last week and said, I don't know, I got this from my accountant. And it turns out that their accountant isn't an accountant. Their accountant is just a notary that dabbles in bookkeeping and is creating companies for people, but doesn't actually know what their documentation is supposed to be used for. So be careful with that.
Is that the unauthorized practice of law, creating entities for someone?
I would argue so, yes. But
Okay.
It's difficult to get people to understand that. And I practice all over the state. I see it from, North Texas to South Texas. It's a problem.
Well, I will say that the operating agreement that was in the corporation I created with my former business partners, one thing, there was just so much trust there. If people that met me since that could have met me before, they'd have been like, wow, you seem really gullible. But then I got spanked for it. So there you go. But one of the things that was not in our operating agreement was that there was a return of capital to the partner that put the capital in the project. Anybody that would have looked at that on my behalf would have said, now what happens, if money starts going out and you haven't had your money returned to you? Well, I know what happens when you don't have that protection. You don't get it back. So if you're okay with going into a partnership and putting money in and not getting it back, just follow what I did. If, however, you'd rather, get your money back, let's learn about some other things that we could do to maybe not have that same thing happen. So let's see. Another area of practice that Miss Sarah engages in is in estate planning, which we've spoken about before. Could you describe in your words, what is estate planning?
Estate planning is planning for your future and the legacy that you leave behind in its simplest form. Essentially, you want to put together a plan for your family and your family's family down the line. That's a lot of people's goals, to go ahead and leave things situated so that ideally your family doesn't have to press forward with probate, in other words, go to court, and all of your assets can be distributed exactly the way you want them to be upon your passing.
Okay. A big part of the goal of Pitranomics is to be able to transfer your wealth. So transferring your wealth after you're gone, you need to really engage in some proper estate planning. So what is necessary, and what's what you wish every person coming to meet with you about estate planning had ready for the initial consultation?
It's really important to have a list of names, addresses, and phone numbers for your spouse, children, or any other persons that are going to be listed as beneficiaries, or essentially who will inherit from your estate. And then if you have any plans to leave specific requests or certain gifts to a loved one, having those detailed out is incredibly important so that we can set that up in your will or even in your trust, as well as a list of properties, vehicles, and anything that you want to designate to specific individuals. In some cases, that may be firearms, it may be tools, it could be a tractor collection. I have a client who left one of those for his family. And then any and all financial information that you want to be listed, such as your checking accounts, savings accounts, and retirement accounts, so that it can make it easier for your family to determine where you had any of those assets. Now, ideally, you don't want your family to have to go to court. It's a lengthy process. So the will that you would create in your estate planning package is one portion of things that you could consider. The other thing that you could use, the other tool that you could use to assist with your assets or transfer assets prior to your passing, is to transfer your assets into a trust. So if that's something that you would like to consider, then myself or another estate planning attorney would be more than happy to create a living revocable trust so that you can transfer property into during that time frame.
Okay. One of the questions that we have is how does a partnership agreement impact a spouse that is not working in the business, if at all? I'm guessing that that's in the realm of estate planning.
It can be, absolutely. It's actually something that tends to be overlooked. So, a partnership agreement is one that you obviously enter, let's just say partner A and partner B. If partner A and B are both married and there is not a consideration for what happens if one of them passes away, then essentially the partnership upon one of the partners passing away would dissolve. Or if there was a provision in their operating agreement, then the partner that is living could continue the partnership, but potentially would go ahead and give any of the profits or proceeds to partner A or B, whoever passed away, their spouse. Now, it gets a little complicated, or it can be, but Texas essentially doesn't want you to be in business with anyone that you don't want to be in business with. So a lot of the times in a partnership, when one of the partners passes, the company can go ahead and dissolve. But in many situations, we've got clients, I myself have clients that enter into partnerships, and we go ahead and draft a separate agreement that says that, or in the operating agreement that says that upon either one of their passing, the company would continue on, but the proceeds received would go to the partner, the surviving spouse. The surviving spouse, however, would not have any say in the business as the surviving partner runs it. Now, if the surviving partner changes their mind, that's a different story. But if you don't account for that ahead of time, you run the risk of potentially getting into a lawsuit down the way. If that partner that is living no longer wants to transfer any assets or doesn't want to give any of the funds, then it can become a complicated bit of a situation. So it's always important to consider who's going to receive any proceeds along the way upon either party's passing.
Okay. I actually have a question that was presented to me. Unfortunately, the person couldn't make it tonight, but let's say you go into buying a piece of real estate together, some unrelated, unmarried people, but they've decided to throw in to buy this piece of real estate, and one of them passes away.
Okay.
How do you make sure that that ownership is in such a way that it goes to the other unrelated owners, and that the heir of the partner or the co-owner that's passed away isn't grasping at ownership of the property?
You can actually transfer. That's a really good question. You can actually transfer or purchase a property so that the deed is essentially in let's say, for example, it's you and me, Julie. It will be in Juli Pitra and Sarah Dill's names. Now, if you fail to add this next section that I'm about to say, then both, if I pass away, you would have my spouse and children to contend with my 50% interest. And you would effectively have to buy out my estate in that particular piece of property. However, if you transfer a deed or you purchase a property in this situation, you purchase a property and the property is purchased under Juli Pitra and Sarah Dill with rights of survivorship, that means that whichever one of us passes away first essentially no longer owns the property, and the surviving owner maintains the property in their own name. So if you wanted to go ahead and sell later, then all that would be needed from a title company would effectively be an affidavit of death, most likely, as well as a death certificate.
So the vehicle to do that is the affidavit of death. Is that something you do at the point of purchasing the property, anytime after? What is
it would be at the point of purchasing the property, or rather, when the new buyer is purchasing the property. So if I have passed away in the situation and you now have the property, once you sell it, the title company closing the deal would likely want that affidavit of death as well as the death certificate. A death certificate may be sufficient. It just depends on which title company and underwriter you're closing with.
Okay. So back to that example, if you and I bought a property, you have a husband and children, I have a husband and children. But our intention for that property is for us to be partnership partners in it. And if I pass, it's all yours. And if you pass, it's all mine. I want to buy this jointly with you with rights of survivorship. Can you explain in a way that's, I guess, clear to me, because keep it simple, how do you specify that type of ownership when purchasing? Is it on the purchase and sale agreement? Is it something you just tell title? At what point does that work?
I think to be able to have the best way to button that up so that my husband or your husband couldn't argue it, it would be on the sales agreement. And then on the deed itself, you're going to write, it's essentially called a joint tenancy. So you would go ahead and write, the grantee in that situation would be receiving the property. So it would be Juli Pitra and Sarah Dill as joint tenants with rights of survivorship.
And just write that on the deed.
Yeah.
Okay. And sorry, my fragment words are being in the comments, but I'm not able to, like I said, get this done. I want to take a quick moment to see if anyone has questions they'd like to ask. I know there are a couple of comments, so if someone would like to let me know and unmute, we can do that while I look at the comments. Okay, I don't know where they went. Okay. Does anyone have any questions for Sarah on what we've covered so far? No? Okay. For estate planning, you mentioned wills and trusts.
Yes.
How are they different? Can you explain that to us?
The major difference is that a will is essentially instructions that you are leaving behind for your family or loved ones to go ahead and take to court. And then the probate court, through that process of probating a will, essentially proves that your will is in fact valid and then gives authority to an executor or executrix, depending on if it's a male or a female person, to go ahead and make decisions based on your estate. Okay, so whether that's selling property or transferring assets, or even taking in rents, things like that, just depends on how big your estate is. Now, a will ends up getting recorded with the county where you essentially passed away, where you died, and also where the probate is opened. The trust, however, is different in that it is still instructions, but a trust is not public information. There is no repository in the state of Texas for where trusts are going to be placed and essentially read aloud. So it kind of can be kept private. Nobody needs to necessarily know who is a part of a trust, whether they're a beneficiary or a trustee, and that's not accessible to the general public. So people that are beneficiaries who are receiving funds essentially or assets from a trust typically know that they have a trust, right? But for the most part, they're not going to be public information. So you do have to be responsible for keeping those papers in order and making sure that you keep a copy, because any sale of property is going to require, under a trust agreement, that the trust be shared with the title company and that the person or persons that are eligible to make decisions for the trust, which would be the trustees, that they are actually able to make, to sign away whether it be assets in real estate or banking information, things like that.
Okay. So I will share that my husband and I started out with no estate plan whatsoever, and then developed our will, our last will and testament, and now have gone to, I won't say it's complex, but more complex than a simple will, set of entities that includes a trust that is not something we really think about. We don't want anything to have to go through probate. We want it taken care of outside of probate, not subject to public information, not subject to somebody else determining whether or not it's valid because we've already put it in place, and not easily contestable. So it surprises me the number of people that don't take those precautions. I think it's because they don't know that they should. They're like, I don't have much, so I don't need to do anything. But trust me when I say I know that even if you don't have much, somebody's going to be fighting over it. So take just a little bit of time to make your your wishes known. I have shared previously that I saw the will that my parents had before my mother died, but it was never, what's the former word, introduced to probate or put through
It was
probate?
never probated.
It was never probated. I didn't have a copy. So if you're going to have a will and last will and testament, somebody should have a copy.
I will say on that front, you actually, it's pretty rare that you're allowed to probate a will on a copy. You can typically only probate an original will, unless you can prove to the court that something happened to the original one, for example, a house fire. At that point in time, there is case law that says that a copy of a will, typically the copy that is on hold with the attorney's office that created that will, can go ahead and go forward in probate. You can also actually have your will and file it with the county, and they can hold it as guardians of your will until your passing, so that the original would already be on file with the county clerk.
There you go. Something that I didn't know. So if you are going the route of a will and you would like to have an official copy kept somewhere in case, there you go. You can file it with the county. Now, what happens if you move? You need to go get that copy back and move it to the next county, or
Typically, once you file it, the county's not going to give it back to you, so you would have to have another will and then put it into the new county.
So that is a consideration.
So the reason, I mean, honestly, I guess it depends on the county, but there's a couple of times where, once you file it, this has happened to me as an attorney where I've confirmed, like, okay, I want to give this to you because I want the judge to review it for certain reasons, right? I've had clients that have passed away, and we've had to probate foreign wills. So they're now U.S. nationals, but they've probated their wills in, for example, like Israel. And so that document has to come not just with the will, but an apostille. All of that had to go in front of the judge. So I actually just made a copy of it and then gave it to the judge rather than give her the original, because as soon as she accepts it, like on the clerk side, they can't give it back. So it's something to consider.
Is there anyone that doesn't know what an apostille is? Because I did not know before I needed to get one.
I don't know.
Let's just cover what that is, please.
Essentially, it's an authenticated document that falls under several countries that follow the Hague Convention. The idea is that an apostille is signed and authorized as an authentic document by a public official in a country somewhere else, or other than the U.S. does it. But effectively, if I needed, say, for example, a birth certificate, and another country needed a copy of that birth certificate, then I would have to go to the Texas Secretary of State, get my birth certificate, and request an apostille. Then somebody in the Texas Secretary of State office would stamp it, give it back to me with their signature, and I could take it to the other country that I needed it in, and they would recognize that as a valid document.
There's a little bit of a wrinkle in what I have, because when I lived in the Czech Republic with my husband, first of all, the Czech Republic requires their documents be in Czech. I mean, that's mighty bold of them. It's already in English. But so they had to be translated officially to the Czech form, then examined for veracity, and then you got the apostille. So it was a time-consuming process, a little bit expensive. So I have those for our marriage certificate and my children's birth certificates and certificates of citizenship, which are different there. And so when everybody in my family, my husband and my two kids, are dual citizens, I am not, haven't met the requirements. But in order to get that, we had to go through this step-by-step paperwork process to get the US documents authenticated. And then they had Czech documents that we don't use. But if I did need to use them, let's say they were born in the Czech Republic, I would probably have to get them authenticated, because it's a completely different looking document. So if my American child wants a birth certificate, that has to be created from the information that's on this foreign birth certificate. and then by not just any translator, some official translator that's for translating documents. Um, that was something that I thought was really cool. I'm glad I know about it now, but I didn't know about it before. Um, let's see, what else did I want to say? Okay, so you have wills and you have trusts. Does anybody have any questions about the two of those? Oh, thank you. Shamir wrote, an apostille can also fall under the responsibilities of a notary public. In our case, we went through the embassy for the parts in the Czech Republic, but then we had to go through, I can't remember the name, somebody, I want to say Minister of Unnecessary Steps with Documentation. I think that must have been his title or something like that, but you had to go through these steps. So keep in mind that if you are trying to authenticate a document, I'd like to know how many of you have your original birth certificate, know where it is, and can lay hands on it. All right. If you don't, would this be a case when you need an apostille to get a copy and have that copy authenticated?
It could be if you need it in a different country, but if you need it in the United States, then the apostille is not necessary. But if you need it in a different country, then yes, it likely would be a situation where you have to authenticate that.
Okay. It's interesting. I have my children's locked away. I have an official copy of mine. So somewhere in the documents my parents had together was my original birth certificate, but I don't have it. Just to be clear, let me just take this time. Get your official documents together, put them somewhere safe so that when it's time to deal with an attorney, thank you. Michelle said, I do. Who's LH? Hi. I can't tell from your initials, but I'm sure I know you. But keep them safe. I have a safety deposit box. Oh, hi, Lamont. I have a safety deposit box that I keep these documents in. Luckily, my husband also has access to a safety deposit box, because really, how valuable is it to be tucked away in a safety deposit box that I have and I pass? How do you get into the safety deposit box? It's more of a process than you can do it, but it's more of a process. So thank you for that. Let's go to the next slide, please, Shamir. I'm really excited about this topic. I'm going to tell you, I'm curious about a lot. So we just,
I have a question, Julia.
Okay, let me just say this one thing and then we'll get to that. I'm curious about a lot. I could take over all of the questions that anybody could ever ask. So I want to pull back just a little bit and say, please get your questions answered. This is such a lovely thing to have a knowledgeable and amazing attorney here to answer questions. So Evan, please ask your question.
Now, she was talking earlier, just a moment about the LLCs and so forth, and also had one about the wills and stuff. Now, some time ago, when I was trying to put a plan together to accumulate some properties and so forth, is it a good idea, like if you get purchase property, pay it off, to leave it in your name or take it out of your name and put it in the LLC so you can protect your assets?
I'm a fan of putting properties in LLCs. I actually have one client that won't buy a property until he has another LLC. So every single one of his properties is in a separate LLC. And that's one way to do it. But you can also use a trust and add a spendthrift clause and, keep creditors from coming at that trust. There's other ways to go about that. But an LLC is not usually a bad way to protect your assets. It's relatively affordable. You can, submit your LLC, or rather your proposed LLC name, and get registered for, $308 and your filing fee for your attorney. So it's a very wise option, in my opinion, and it helps protect your assets, especially if you don't have like an umbrella policy. So if you're in a car accident and you run a business and you're commingling funds, it's the best option to go ahead and move your properties into an LLC.
Let me just ask, you mentioned a spendthrift clause. If, for those that don't know what that is, can you give us a little bit of a description, please?
Sure. A spendthrift clause essentially prevents prevents creditors from coming after your trust assets. So if you have a loved one who is maybe a minor, because you can leave assets to a minor in a trust, or an individual that maybe doesn't quite necessarily know how to handle their own finances just yet, you can go ahead and add a spendthrift clause so that a creditor, say Bank of America, cannot necessarily come once they realize that you have a trust and then request or demand payment from the trust itself. So it's a way to kind of, again, just keep your assets a little bit more buttoned up.
There's a question from Shantae. For your estate planning professional services, are your estate planning services a tax write-off?
I think theoretically they could be. As far as I understand, they are. You can have legal fees as a write-off throughout the year. So if you pay if you pay an attorney for estate planning purposes, as long as you have your receipts, I don't see that being an issue.
Is it a write-off basically against your business, or you can write it off if all you have is W-2 income?
I think you can write it off with W-2 income. I'm not an accountant or a tax planning professional, but in my own personal experience, I remember seeing that question from my CPA both times. My legal fees, which is funny, legal fees that I might have paid as a business, and then also legal fees as an individual.
Okay. You touched on something that I like. You, as an attorney, if you need an attorney, you get an attorney, don't you,
Yes.
Sarah? You don't act as your own attorney.
That is correct. There is a little known saying that an attorney who has themselves as a client has a fool for a client. So it's really important. And I know off the top of my head, if I was in trouble in a certain way, shape, or form, which attorneys I would call at the drop of a hat if I found myself in one of those situations.
And that's great to know. One thing I want to say about Sarah, she's extremely personable. She's also bilingual. She didn't mention that, and I didn't mention that, so sorry. And not just bilingual that she speaks Spanish. She understands some of the nuance in speaking to people whose first language maybe isn't Spanish. That's important because sometimes intent is clouded when you don't understand the nuance of a language. But I was actually not represented by Sarah. She was a partner. Is that correct? Or an associate? An associate in the firm where I worked. And I don't know, we just started talking, and I don't know, then we went to dinner, and you have to build rapport with your professionals. But in addition to rapport, you have to feel confident that they are competent, say that many times, confident that they are competent to do what it is you want them to do. So if we were to go to Sarah's website and look at her areas of expertise, don't go and say, hey, can I get you to do something off the wall? Maybe she can. She's probably willing to refer someone to you that she respects. I would find an attorney's referral that I respect a very valuable partner as well, because they know you and they've worked with you. So I at one point I did have to call you because it wasn't your area of practice on a little situation that we had, and I guess that's over. So please remember, this whole discussion today is about getting professional help. Sarah has given up her time and she's come here. I would love for you to give her business, but set up a consult. I am recommending Sarah as an attorney. I have recommended her to others. I think she is amazing.
Thank you.
But everybody has to find out if she works for them. She works for me. So please make sure you get her information. I have one more question, if someone will just let me ask this question. And how do I say this? I went into a very expensive joint partnership with no protection at all. If I had to do it all over again, I would have had my business partners, and we would have gone in and talked to Sarah or her other, I guess, managing partner at the time. We would have sat down and I would have listened to all of the potential catastrophes that could have befallen a partnership. Because here's what happens. When you go into the partnership, when you go into a marriage, you're very optimistic. Everything is wonderful. You can't conceive of things going downhill. You need someone that can absolutely conceive of the things going straight to hell in a handbasket and to help you prepare in case it happens. That doesn't make it happen. It prepares you in case that it happens. So I hear from so many people, we don't need a lawyer, we trust each other. Or we don't need a lawyer, I know things are going to go well. I still hear that. Even people who know what I have been through will say, yeah, I don't think that's going to happen with this partnership. Well, nobody thinks it's going to happen going into the partnership, or else they wouldn't go into it. So as soon as you start to feel that overwhelming optimism, go ahead and back up and say, let's just talk to somebody that's not so optimistic about it. Maybe that has, they have seen some things. And in my conversations with my attorney during my whole process, he would just off the cuff share an anecdote. And I'm like, ooh, oh. These things happen all the time. It's not rare that a partnership dissolves in an acrimonious fashion. It is more the norm. I don't know if that's true. Is it more the norm, or is it just I'm now tuned to seeing it?
I think you're probably tuned to seeing it, but I do have plenty of clients that come in and say, like, thanks for talking with us, but we don't think that's us. That's not going to happen. And I almost always will say famous last words. I told you this is a possibility. And I often write a closing letter, right, for those situations. Like, these are the things we've discussed. This is what I advised you of. I am not representing you in any of these matters. Best of luck. And I mean that genuinely. Like, hopefully nothing goes wrong. But my husband says something that I really love. It's only an overreaction if nothing bad happens. So it's really great to have the contract. So you spend, if you have me custom draft a contract, I may spend anywhere from $25,000 to $5,000 working on a contract for individuals or entities, depending on what they need. So, okay, you pay, let's say maximum, for your situation, you pay $5,000 to me.
I would have considered that a blessing in retrospect.
That's exactly what I was going to say. You're going to have saved thousands of dollars in avoiding a lawsuit and avoiding, really, you might lose a friendship along the way if there's a dissolution that occurs. But if all you had to pay was $5,000 up front to make sure that you buttoned up your business, I guarantee you it will save you thousands, if not hundreds of thousands of dollars down the road.
Not millions of dollars.
It could be a lot more. You're right. And it's really important, especially when you're dealing with real estate, anything that's going to touch your livelihood, you want those contracts. If nothing bad happens, great. But you've got that contract in case it does. So I mean, more times than most, I feel like the contract comes into play. And I will say, like, I'm an attorney. I invest in real estate. I've invested with my friends, and we have an operating agreement, and we have an entity, and we make sure that we communicate with each other about what we like, what we don't like, and how things are going. Because if you don't communicate and you don't have a set of bylaws to follow, then you're working in the Wild West, and that's not going to be a fun place. So it's really important to go ahead and discuss these things ahead of time and make that little bit of an investment in yourself and in your company in order to hopefully be as successful as you can be in the long run.
I love that. And one of the things that I will just say I hear a lot as a landlord is a tenant trying to define their rights to me based on some law. And I try to be diplomatic when I say, well, we have a contract. It's called the lease. Have you looked at the terms? Do you understand the terms? The lease agreement in Texas is longer than the purchase and sale agreement, and there's a reason for it. So I, for the most part, will read every single word of a contract that I sign. What I don't tend to read in more than once is like when I get a software, I read all the terms and conditions. I might not read the updates. Maybe I should do that. But first make a habit of reading the stuff that you're signing, because if you don't know, that's not an excuse not to adhere to the terms of the contract because you didn't read it. And something else I hear, well, you didn't tell me that was in the contract. I was dealing with someone a couple of years ago who bought a property, signed the loan documents, and then it was time to sell, was upset that she had an obligation to fulfill as a result of the loan documents. And it was like, well, nobody ever told me that. And I was like, is English your first language? Did you read the documents? I mean, I didn't say it quite like that. I'm sure I said it slightly nicer. I don't know. But I mean, seriously, because you don't bother to read it is not an excuse for not understanding the contract. Is that correct, Sarah?
That's correct. That is absolutely correct. And it's really important to review it. In fact, in a lot of my contracts, especially when I don't represent both parties, I write in a clause in very large black bold letters that says at each party here is of sound mind, is over the age of 18, understands what they're signing, has had the opportunity to review what they're signing in advance, has had the opportunity to seek counsel, and has been told that they need to seek counsel by undersigned counsel. So it's a way to make sure that you're protected, and also that I protect myself, right? Especially if somebody doesn't have an attorney on the other side and they're negotiating. So it's very important to review what you're actually signing and to understand that everything you sign is likely binding.
Yeah. And even as a realtor, when I issue a purchase and sale agreement, issue a contract, an offer, there's a part where I have to disclose that I'm a realtor. So it's clear that I may have a knowledge advantage over the person I'm negotiating with if they're unrepresented. Mm-hmm. That is my duty because of my experience and my license. But that's not saying, oh, I know more than you do. There are people that I believe know more than I that don't have a real estate license. But that is an important disclosure so that the other party understands I may know a little bit more. I do this on a regular basis more often than the average person is buying, selling real estate. So I have that experience. An attorney sees a wide swath of what can happen when you're not protected. They might be seen to not be able to take advantage. Having those kind of disclosures protect her is like, I did due diligence to make sure you understood and you had the opportunity to further understand your position. Take advantage of your professionals. This is an amazing person. I think last week or the week before we had a CPA. And here's the thing, it's not necessarily all that exciting to sit down beforehand with an attorney and hear about all of the things that could go wrong, but it's probably way more exciting and much more pleasant than the reaming you get when you don't.
Mm-hmm.
So, and I just want to make sure those that don't know me, I have been reamed painfully. Sarah knows. She watched. Yeah, she watched it. What could you do? I hadn't taken the precautions. So before we kind of just log off, does anybody have any other questions? If you have them, let's get them out there.
I got something.
Okay.
I know, like what you guys were just talking about. When the average person go into like first time buying a home or signing an important contract, or even a young person who just moving out of the house, getting into an apartment, a rental agreement or whatever, a lot of times the emotions lead them and they're not looking at the words or what they mean or how much it can hurt them when they're going in like that, because the emotions makes them vulnerable. And that's what happens with a lot of people. Yeah, they sign the contract, they have a feeling of trust because you built a rapport with them. Okay, I'm not gonna sit here and read all of this stuff, and I'll sign. How many times have we looked at something on the internet or whatever, and we want to get to a website or make a purchase or whatever, and they got the terms and clauses in there, and you click on the link and all that stuff, and you see all this stuff in the terms and clauses and say, I'll just agree to it and move on. And most people are like that, and they're not looking at it because their emotions kind of cloud their judgments. So what do you say to someone to give them a bit of an advantage or some help when they make those type of decisions based on their emotions and not actually looking at the situation for what it is?
Well, unfortunately, in those heated moments, those situations where your emotions are guiding you, that tends to be when I'm cleaning up a mess, when my client has come to me after they've already done something they shouldn't have done. So I think it's really important to constantly remind other people, clients, or any of your friends and family, like, it's really important if you're being asked to consider or weigh a decision that's going to affect your livelihood, where you actually physically live, or anything that deals with your finances. It may be required to have somebody else review documents. I have had clients that have already started negotiations for, say, commercial buildings, for gyms, for one recently. And she sent me a contract. She said, "Sarah, can you please review this? You came recommended by a friend of mine who I went to law school with." And I said, "Absolutely, happy to review it." She paid my consult fee. I reviewed the document. I effectively bled on it and said, "I don't like any of this." And I knocked out a bunch of stuff. I said, "This doesn't protect you at all. When's your next negotiation talk?" And she wrote back and said, "Oh, I actually already agreed to half the things you didn't like because I really want this space." So she had opted, because she was so excited, not to talk to me ahead of time, and had already gotten herself into a contract unbeknownst to me, and quite frankly put herself in a position I wouldn't have wanted her to be in. But she was so excited about this business that she had already promised that those particular clauses would not be removed. So I wasn't able to remove the teeth of the contract or much of it because she'd already committed to it. I think it's hard in those situations, sir, to go ahead and say, you should think about XYZ. Once you're already there, it's a problem. But if you start talking to people ahead of time and say, "Hey, you know what? Pay the $150 consult to talk to an attorney," or thereabouts, so that they can review these documents and let you know what their thoughts are before you do something. If I could do that for almost every single client, my business would look very different than it does. Being able to,
as many messes to clean up.
Yeah, there would not be as many. But the part of the problem is the emotions that people get into. I handle a lot of things in real estate, from landlord-tenant law all the way to contracts and title issues, disputes on easements, to everything in between with businesses. So I get to see a lot of situations, from partners to owners and businesses, as well as tenants. So it's a lot of things to consider. And going to a knowledgeable attorney, again, it doesn't have to be me, but going to somebody that sees these situations on a daily basis, you're going to get more information from how not to do things so that you can avoid problems in future, as opposed to just relying on maybe your circle of people, which may be great, but the likelihood is that you see a lot more positive outcomes than negative. So most often individuals don't think that the bad thing can happen to them.
That's true. That's true. And when the bad thing does happen, it's hard to extricate yourself from that situation.
Facts. Yep.
So, well, anyway, thank you so much for spending your time to come on. We've got your contact information up again. I hope you've captured it. And this was amazing. Thank you.
Thanks again for inviting. If you all have any other questions, please don't hesitate to reach out. My email address is there, and that is correct. There's no .com. That is the proper domain. It's sarah@dill.legal. Feel free to send me an email or call my office. I'm always happy to answer as quick as I can. I have a typical turnaround time of about 24 hours. Julie can tell you, I tend to be pretty fast.
She's great. So thank you very much. I hope you guys have all joined. I'm going to end the broadcast. If you're on YouTube, please subscribe, like, and comment, or whatever it is you're supposed to do. I'd love to extend my reach. I hope you have found this information useful, and I'll see you guys again next week. Take care. Bye. Mwah.